Today we're discussing two important recent decisions relating to judicial bias from the Supreme Court and the High Court of Ireland. These rulings clarify the law on when a judge should step aside due to personal connections or perceived bias. Having a clear and effective approach to address perceived judicial bias is crucial for maintaining public confidence in the legal system, and these decisions give useful guidance. Public confidence in the judiciary is a serious concern. However, a system whereby every complaint or challenge means a judge has to recuse themselves or step aside would be too sensitive and would make the legal system unworkable. But too low a standard would damage rather than promote public confidence. The courts have therefore established defined limits on measures to guard against perceived bias. Two recent rulings provide clarity on whether and when a judge's relationship with someone involved in a case or their own conduct in court might require them to recuse themselves. Let's start with the Supreme Court case, delivered earlier this year. It involved an appellant engaged in long-running litigation against University College Dublin, dating back to his unsuccessful application for a master's course in 2001. The case eventually came before Mr. Justice Meenan in the High Court, where the appellant alleged that the judge was biased. One of the key complaints, and the one which the Supreme Court heard, was that the judge's son worked as a senior associate at the law firm representing UCD. The appellant argued that this connection meant the judge should have stepped aside. The Supreme Court disagreed. The Supreme Court confirmed that Irish law does not have a rule of automatic disqualification based solely on relationships. It is not the relationship per se that disqualifies, it is the relationship having regard to the role played by the individual in the proceedings before the judge. The Supreme Court reaffirmed the test for bias as whether a reasonable and informed observer might have a reasonable apprehension that the judge would not be able to give the matter an impartial hearing. To determine whether bias might be said to exist in the context of a relationship with a judge, the court set out key factors to consider in the context of that relationship: the extent of the relative's involvement in the case, whether they have a direct financial interest in the outcome, their connection to the lawyers actually handling the matter, and the size of the law firm involved. In this case, the judge's son worked for a very large firm, but had no personal involvement in the case and no financial interest in its outcome. The Supreme Court therefore ruled that this meant the judge was not disqualified from hearing the case, and therefore did not need to recuse himself. Now, let's look at a subsequent High Court case that applied some general principles from that Supreme Court decision. This case involved a judicial review application concerning a district court judge in family law proceedings. The applicant here claimed the judge was biased against him, particularly because she had handed a copy of a statute to the opposing barrister during a hearing. The High Court considered whether this act could create a reasonable apprehension of bias in the mind of a reasonable person. Applying the same legal test from the Supreme Court, the High Court ruled that there must be a cogent and rational connection between the concern raised and its potential to influence the judge's decision. The court made several key observations. Judges do not sit passively, but can assist in clarifying the law. Handing a copy of legislation to a lawyer does not constitute bias. Repeated applications for recusal do not amount to proof of bias. And formal complaints against a judge do not automatically create an apprehension of bias. In this case, the High Court found that the allegations did not meet the applicable test for bias and rejected the application. These decisions are important as they confirm that judicial bias must be assessed objectively. A judge will not be required to step aside unless there is a real and reasonable apprehension that they cannot be impartial. These rulings provide reassurance that claims of judicial bias must be based on clear, logical and cogent evidence. It also sends a strong message to those who may be minded to allege bias that judges cannot be disqualified merely based on unfounded allegations, complaints or repeated recusal applications.